Imagine spending thousands of dollars setting up your living trust only to accidentally wreck it by putting the wrong asset inside of the trust. Most videos will tell you what you should put in your trust, but almost nobody talks about the assets that can blow up your tax plan, cause insurance nightmares, or drag your trust into lawsuits. So today we're flipping the script. I'm going to show you the exact assets you should not put into your Indiana Living Trust and why kicking them out actually protects you. I'm Guy Martino, an Indiana estate planning and probate attorney, and by the end of this video, you'll understand the do not put in trust list better than 99% of people who already have an existing living trust. So let's jump in. Let's start with the one everyone asks about: vehicles, boats, equipment. Putting your car into your trust is kind of like putting your toaster into your will. It's unnecessary and just creates headaches. Well, here's why. For most people, the car they're driving the day that they actually sign their trust is probably not the car that they're going to have later on or at the time that they pass away. First reason why you shouldn't put your vehicle in your trust is because vehicles transfer easily without probate. And also, you're going to sign an assignment of personal property, which will also handle the transfer of your vehicles. In Indiana, all your trustee needs to do is go into BMV with a copy of the death certificate, copy of the will, or a copy of the trust. The paperwork is filled out and it's done. The vehicle is transferred. Here's an example. You want your truck to go to your son. Instead of retitling it into your trust, you can simply write this in your personal property memoranda or your final expression. Your trustee takes the death certificate to the BMV, signs the form, and boom, it's done. The second reason you don't want to put your vehicle in trust is liability. If your car is titled in your trust and someone gets into an accident while you're driving it, guess who gets named in the lawsuit? Yep, your trust. Your successor trustee, the trustee. Keep vehicles in your own personal name. Keep your trust out of the courtroom drama. The third reason is insurance confusion. Insurance companies get confused when vehicles are titled in a trust. Sometimes the coverage is wrong. Sometimes they refuse to insure it. Unless anonymity is your top priority, avoid putting vehicles into your trust. Next up, retirement accounts. These accounts have one rule that almost nobody understands. You should never transfer ownership of your IRA, your 401k, or any other qualified or tax-deferred plan into your trust. Why? Because doing so is changing the title. And when the IRS looks at that, they're going to consider that a liquidation. You'd pay taxes on the entire amount immediately. Here's an example. Say you have 400 grand in an IRA. If you retitle it into your trust, the IRS treats it as if you withdrew everything in one day. Massive taxes, and if you're under a certain age, massive penalties. So what should you do? Name the trust as a beneficiary, not as an owner. This avoids probate, preserves tax benefits, and allows your trustee to control when and how your kids or whoever else is your beneficiary will receive the money. If your kids are young or financially inexperienced, your trust can stretch out distributions so they don't blow it all at once. Sometimes too much money at one time can cause heartache to kids. Now let's talk about annuities. Annuities are similar to retirement accounts. They operate under their own contract, and they already have beneficiary designations. If you transfer ownership to your trust, you could trigger some tax penalty or void the protections that you might get through the annuity. Instead, keep the annuity in your own name, name your spouse as a primary beneficiary, and then your trust as a contingent beneficiary. Here, you keep the tax benefits and your trustee can still control payments after you pass away. Now let's talk a little bit about life insurance. Life insurance generally should also stay out of your revocable trust. Why? Because naming beneficiaries already avoids probate. So you don't want to title it while you're alive in the trust. Here's an example structure. Your primary beneficiary should be your spouse. Your contingent beneficiary, your trust. That way, if both you and your spouse passes away, the trustee can manage and distribute the proceeds. And here's a pro tip. If you have a potential for an estate tax issue, or if you have a large life insurance policy, $1 or $2 million, you might want to consider an irrevocable life insurance trust. That's an ILIT, because that money is a revocable trust and it removes the policy outside of your taxable estate. So those funds can be used to support your trust or to pay some type of inheritance tax if that's going to be required. But again, don't put your life insurance inside your revocable trust while you're alive. It typically does not have any benefit to you. So here's the simple rule. If an asset already avoids probate, or if the asset creates some type of tax or liability issue when it's retitled, keep it out of your trust until such time as you pass away. So here we go. Vehicles, out of the trust. Retirement accounts, most of them, out of the trust. Annuities, out of the trust. Life insurance, out of the trust. Everything else, in the trust. Anything that could potentially be titled in your name only at the time of your death should go into the trust so you can avoid having to go to court and have to deal with probate. Knowing what not to put in your trust prevents accidental hits on taxes, accidental exposure to liability, and expensive legal problems. Now that you know which assets should stay out of your trust, your next step is understanding the assets that you should put in your trust. So why don't you meet me in our next video where I'll walk you through exactly the 5 ways to properly fund your Indiana Living Trust. I'm Guy DiMartino, and I'll see you over there. Have a great day.